organized the schedule is any indication of this case, we're in. But thank you anyway.
Okay, so, nothing changed on this from what was sent yesterday, right? Okay.
That's why I wanted to check again, just to make sure. There were 10 emails this morning about this.
Oh, well, I didn't have 10.
Well,
I think I only had 2.
No, I have more than 2 though.
You're gonna be my bad.
Yep.
Didn't you guys circulate a call-in number? I circulated, at least I assume, if she sent it to him, if she sent the call to him, no, if she sent the call to him too, then I haven't heard anything back, so. All right, well, good, okay. That was it.
It's 1 o'clock now, bye.
She brought it in.
Good afternoon, everyone, and welcome to the Public Service Commission meeting. Before Ms. Iori and Mr. Geddes start praising Delmarva Power and Light, I like to praise them first. And that is thanks to Delmarva for its fine work in Sussex County. We had a surprise overnight. I slept through it, but a lot of people didn't because they had damage and a lot of damage in some areas near Laurel. So our thanks to Delmarva Power for their continuing work in that area to restore electricity.
I will stress that to our line folks, because I know they were really putting it, within some hours to get that restored.
You got an early morning wake-up call, that's for sure. Yeah. Okay, on the agenda for today, April 16th, we have the reading of the meeting minutes of April 2nd. Are there any changes or corrections to the minutes?
Move approval of the minutes of April 2nd.
Second.
Everybody second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed, any abstentions, the motion carries. The consent agenda, are there any items on the consent agenda that a commissioner wishes to have put on the regular agenda? If not,
Move that we adopt the consent agenda as presented.
I second.
is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any noes or abstentions? It passes. On the regular agenda, we have the one of interest, which is the number 1. It appears, I see that we've got some non-Delmarva people here. I was going to try to be as commodious to everyone as possible who's, by not going with number 1 first, maybe put it at 4th, but it appears that all of the other matters are Delmarva Power and Light. And Bill, I guess you're just here for the fireworks.
Thank you.
Did you bring our executive director's helmet? I wasn't sure if you.
Now I can.
Oh, look, oh, you did. Oh, thank you, Ms. Iori. So it looks like we're prepared. We'll might as well leave that number 1 so we get that over with. And we have, I guess we have, besides the application and the exceptions, we have a motion to continue that appeared on our doorstep. So if the parties would appear and come up to the front.
Mr. Chairman,
Yes, sir.
for this docket, Councilor Bob Willard is your legal advisor.
Thank you very much, Mr. Brewer. Mr. Skaggs, whenever you're ready.
Thank you. Yes, thank you for your patience.
R.J. Skaggs here of Morris Nichols Arston Tunnel on behalf of Delmarva Power and Light. Yeah. The applicant and the movement on the first motion, and thanks for hearing us today. The Delmarva has moved for a continuance of the hearing on the exceptions that staff and DPA have taken to the Phase 2 decision in its gas rate case, where the hearing examiner found that Delmarva should properly recover about $3.4 million of labor cost associated with replacement of batteries in the interface management units of its gas meters. And I think this motion raises really issues at two levels, and one is, what would the commission see as fair and would best serve the adjudication process in this case? What presentation of written legal arguments will allow the commissioners to make a well-informed and deliberative decision here? Secondly, on the second level, what does the commission want? And this does raise broader issues, and this is why Delmarva is doing this, because it does raise broader issues about how things come before, written submissions in particular, come before this commission, and we think the commission should make decisions about that. What does the commission want to be the process for parties to bring written submissions before the commission for consideration prior to hearings? So, real quickly, what happened here: the hearing in Phase 2 was held on September 12, 2018. Findings and recommendations were issued by the hearing examiner on February 14, 2019. That made exceptions due on March 6, 20 days later, according to the PSC rule and the statute. DPA requested and received, with the agreement of Delmarva, which a council in Delaware often does, and that's fine. We don't want to meddle for that, but it received an extension until March 11. That also moved, we believe, the hearing date to today. Delmarva did then review the exceptions filed by staff and DPA. There was some, of course, unfortunately, some trouble with schedules, and even had some family health issues that got involved that ended up having Delmarva produce a responsive brief later than we would have wanted to. But Delmarva did notice the detailed arguments on particularly on three different case law decisions related to the standard that this commission uses to review utility expenses and expenditures, whether and when the business judgment rule would apply. We saw that as a potentially precedent-setting issue and wanted to be able to file written legal arguments on it. So Delmarva did file their brief on April 11. The executive director responded by giving options to Delmarva, saying either you show up on the 16th and you argue without your brief being sent to the commissioners, or we'll postpone it. But if we postpone it, it'll be moved to a different hearing date, obviously, and I'm going to give staff and DPA a chance to respond to your filing. And we said that was fine. The DPA filed a response to the executive director's original decision, encouraging him to reverse that decision, which he did. We also sent another email saying, please don't reverse your decision, but he stood firm, and so we're here today, and we filed a motion for continuance yesterday, and DPA filed an opposition. Now, with respect, and remember I said there's two levels here, with respect to the reasons why we would believe it would be appropriate and in the best interest of the adjudicative process of this body for you to receive and review our brief would be, the first reason is it is an administrative body. The understanding has been, I think, at Delmarva and in other utilities I've represented, that you have a flexible process that allows the commissioners to receive a variety of filings when it is important that the commission hear particular arguments or from all sides of a dispute. To our knowledge, there's no rule that would prohibit a reply here. The rules that have been cited to the executive director, and you'll hear about, no doubt, one is a PSC rule, one's a statute, dictate what is required for the filing of exceptions. That is, a party to notify this body and the other parties that it does disagree with the hearing officer's report, that we are taking issue with that, as in the filing of an appeal, say from a court case, and what exactly they're appealing. Now, in a court case, to analogize, it may not be completely appropriate, but to analogize, then after that, of course, both parties file briefs and you go to the court and argue it. Here, it's often been the practice that parties do not do anything other than file exceptions. That's often, in our view, in cases where there's a lot of smaller, often factually based issues, smaller dollar amounts, and much less precedential, and the parties are happy, based on the way they see the dispute, to come in and argue just based on those exceptions and let the commission decide that. Delmarva sees this particular issue in the 37-page brief filed by staff at DPA, certainly their prerogative to do so, a very long, detailed brief, as being fair to allow, Delmarva to respond, and that it would be helpful for the commission to read our brief, which is shorter, and I know it's an issue about how much you need to read. We understand that. This is an important issue, or we wouldn't ask you to read those extra pages. And the brief we attempted to file was, I think, about 27 pages. So in light of this case, this one, what we see is it's really this one, mostly a one-issue case, and we see this highly important. We don't believe the timing should be an issue. We know it probably could have been filed earlier, but we've certainly, and were offered originally by the staff, by the executive director, to have this come in and to take more time. It's Delmarva, I guess, that wouldn't recover this as soon, and it's fine with giving them more time. We understand that. So we don't think the timing should be an issue. I think what the argument we're facing is all you get to file is exceptions. And that's what the rule says. That's what the statute says. Our view of that would be, it says that's what you need to do to take exceptions, but does not speak to any further filings or prohibit them. So that's our issue on that. Now, the other level here is what is the practice here with respect to, are there rules with respect to filings before the commission takes up a matter? Here we have the executive director, who is the head of the staff, who is a party opposing the application here, making a decision on what the commission sees before an argument. Now, I think what we've heard from DPA is that decision, the executive director making those kinds of decisions, is not a violation of the minimal due process guarantees under the Constitution. That may not be the case. My appeal to you today is that really all you want to provide, assuming that it even provides it, because what it certainly looks like is if the prosecutor in a criminal case could decide which briefs of the criminal defendant the judge got to read. And we don't think that, we think the commission, if that's the way that's going to work, then the commission should decide that and make that clear. But that's what's happening. And that's what happened here. Not only did it happen here, it was a reversal of the initial indication, which we thought was a common sense solution, to put it off and allow you to read that. So we have the ED making those decisions, the executive director making those decisions. And I think the confusion here is this is not something that is reliable within the community as to exactly how their filings are going to get treated. And I think Mr. Goodman has a bunch of examples, but I would ask him to just fill you in on perhaps one that he's lived through, so you can understand the context that we're talking about here when it comes to what are the rules on these filings.
Your Honor, with all due respect, I object to being tag teamed. Delmarva has a lawyer who is speaking. It is unfair for us to have to respond to two different people. And I grant you that if it was on the shoe was on the other foot, they would be objecting.
We've done this before. I didn't think it was a big deal. I don't think I'd object, but
You have done it before when it has not been objected to. I am objecting to it.
You want to carry the ball, please, Mr. Skaggs?
I can do that. So the one, and we have several examples. So So in docket 64, opened in October 9, 2018, staff provided Delmarva with a copy of a petition to open a rulemaking docket and with extensive proposed rules, a proposed opening order on Wednesday, October 3. Delmarva was required to provide any comments on the same materials before the same materials were sent to the commission on October 4, which gave Delmarva only 1 day to review a brand-new petition to open a rulemaking docket, the proposed opening order, and the actual proposed rules. Delmarva asked staff to agree to a continuance to give Delmarva more than 1 day to review the petition, proposed opening order, and proposed rule. Staff refused. At the commission meeting, Delmarva noted that it had not been given a reasonable opportunity to review the petition, the proposed rules, the opening order, and stated that it would not object to the opening of a rules docket, but didn't think the rest should be ordered. The commission entered staff's proposed order, and here was the result. Once Delmarva had an opportunity to review the proposed rules and the opening order, it became apparent that the opening order proposed by staff contained a clause providing that the proposed rules would take effect immediately. That violated the APA. And secondly, that the proposed rules contain language that would eliminate Delmarva's ability to achieve any DSIC, D-S-I-C, and you know, I'm sure the commissioners know what that is, recovery in electric cases, or in electric utility service. And that was also in violation of the DSIC legislation. So what had to happen? Delmarva was forced to file a motion to modify the opening order, which staff eventually agreed to not contest, and the opening order was modified to remove the illegal language. All that was due to the fact that staff provided Delmarva with 1 day's notice. And by the way, the commission was provided with only 5 days' notice. Brand new docket, a whole set of rules. So this is why, and I have other examples, and I don't want to get into them because I don't think it's going to be helpful to get around here and start pointing fingers, but this is the context in which you got the filing of the brief on April 11th. People really don't know, and they really do feel like the staff will just order stuff and put stuff on the agenda, and when it comes to you as the utility, you may or may not get it before the commissioners, depending on what the current status is. Do we need it? They've heard different things. Do we need to get it in 2 weeks beforehand? It was Thursday. I remember from some of my older cases, Thursday before the Tuesday meeting. There's no particular rule, and it looks like discretion of the executive director, who in this case is a party. So that's why we think overall this is an issue, and we think that in this particular case, it would serve the commission best to put this off until all the, and I think DPA or staff's counsel can't be here at the next meeting, but we go to whatever, everybody could be back. You could read the brief, they could file a response on this important issue. So that's our motion for continuance. I appreciate you listening to me.
Thank you, Mr. Skaggs. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. I will be carrying the ball on this one for staff and the DPA. I'd like to start out with a quote from the musical Hamilton, or actually it's more of a paraphrase. This was Alexander Hamilton responding to Thomas Jefferson. RJ, that was a real nice declaration. Mr. Skaggs says that you have to address this on 2 levels. One, what is fair and best serves the adjudication in the case? And second, what does the PSC want? You did not hear anything about the Administrative Procedures Act except for the discussion of regulation docket number 64 when Delmarva said that staff's proposed order violated the Administrative Procedures Act. The Administrative Procedures Act gives this commission its marching orders. You are subject to it, and you cannot change it. So I will get to that, but I would just like to start out by addressing why we're even here in the first place. This is a problem of Delmarva's own making. Delmarva has had staff's and DPA's joint brief on exceptions since March 11. It had our brief for a month before it filed these reply exceptions. Now, Mr. Slater wanted me to calculate the number of days, hours, minutes, and seconds, as he had done before. I told him no, it was 30 days. During the 30 days in between the receipt of our brief and when they filed their reply exceptions, there were 2 regularly scheduled commission meetings, March 19th and April 2nd. Delmarva could have requested the commission for leave to file reply exceptions at either of those two meetings. And it could have requested the executive director for such leave at any time during that month. It did not. Instead, it waited until after the close of business on the Thursday before this oral argument was scheduled, and it has known about this date since March 5th, to file a reply brief with a more than 400-page compendium of cases, and without having received approval to do so. Now, this is not the first time Delmarva has waited until the last minute to request relief from this commission on something. I'm sure you all remember the electric vehicle docket and the report that they sought to submit with rebuttal testimony a week before that testimony was due. I suggested to the commission then that if you granted Delmarva's request, it would not stop there. And so here we are again. Delmarva has created this crisis, and the commission should not reward it for doing so. But if you grant their motion for a continuance, that is exactly what you'll be doing. And you'll also be signaling to other utilities and to staff in the DPA that they can wait until the last minute to request relief that they should have and could have requested much earlier. Now, moving on to the legal arguments, and we'll get to the APA. You will search Delmarva's motion in vain for any acknowledgement that the APA controls what this commission can do, but it does. Mr. Slater will be handing to you the pertinent sections of the APA, and I will direct your attention to section 10101.
Thank you, sir.
Now, section 10101 provides that the purpose of the APA is to, and I quote, standardize the procedures and methods whereby certain state agencies exercise their statutory powers, end quote. And I emphasize the phrase standardize the procedures and methods because that's important. This commission appointed hearing examiner Lawrence to conduct the evidentiary hearing in this matter. That appointment triggered application of section 10126, which is also attached. Subsection A of section 10126 required the hearing examiner to prepare a proposed order that included a recommended decision, recommended findings of fact, and recommended conclusions of law. Mr. Lawrence did that. Subsection B of section 10126 provides that Mr. Lawrence was then required to submit to the agency, to you, his proposed order. And after that, parties would have 20 days to submit written exceptions, comments, and arguments regarding the proposed order. That is it. That is all that is permitted. One shot. And the exceptions, comments, or arguments must address the proposed order, not another party's exceptions. Now, recall that APA section 10101 states that the purpose is to standardize the procedures and methods whereby state agencies exercise their statutory powers. Delmarva is asking you to depart from the standardized process that the General Assembly has prescribed. It does not even acknowledge that the APA applies. Instead, it argues that nothing in the Commission's rules prohibit reply briefs to exceptions. Delmarva's counsel has been practicing as long as I have, and I know that he knows that statutes trump agency rules. And as I have argued to this commission previously, statutes must be interpreted to affect the General Assembly's intent. APA section 10126B is clear. It gives parties to an administrative proceeding one bite at the proposed order apple. It does not give the parties the right to submit reply briefs to the exception that another party files. Now, there's case law, and we cited it in our opposition to the motion, that when a legislature does not include language in a statute, that omission is deemed to be purposeful. If the commission rules otherwise, it will be adding language to the statute that is not there, and it will be committing reversible error. Even if the commission's rules allowed reply briefs on exceptions, which they don't, that would be inconsistent with section 10126B of the APA, and those rules would be invalid. Now, Mr. Slater is handing out copies of the rule upon which Delmarva relies and the commission's rule regarding exceptions. Now, the rule upon which Delmarva relies in its motion, 1001.1.7.1.6, states only that a brief is a filing. The rule that explicitly addresses exceptions, Rule 1001.2.19, is consistent with Section 10126B of the APA. The only time Delmarva acknowledges Rule 2.19 exists is in its assertion that the briefs on exceptions weren't filed within 20 days of receipt of the proposed order, and that is true. Delmarva did not tell you that it agreed to the extension in its motion papers, but Mr. Skaggs has conceded that they did agree to that brief extension. That's what I represented in my letter to Dr. Barua requesting the extension. And in return, Mr. Goodman had asked that the oral argument not be scheduled until today because he had previous commitments for the 2 prior commission meetings. Neither staff nor DPA opposed that request. And no one from Delmarva took issue with my representation in that letter that Delmarva had agreed to the short extension. Staff and the DPA filed their exceptions on March 11th, and so did Delmarva. Now, if Delmarva's point about the 20-day period being violated is that if its reply brief is not permitted, then all of the exceptions filed on March 11 should be ignored because they were untimely filed. The DPA is okay with that, and we speak only for ourselves on that. Staff does not necessarily agree. But you can go ahead and enter the hearing examiner's proposed order today. That will save this commission and the parties a lot of time and reduce a lot of carbon dioxide emissions coming from all the hot air you're hearing today. And the DPA will file its appeal and its motion to stay the order tomorrow. My point is that all parties agreed to extend the 20-day exception period and received approval to do so. Parties can waive a statutory right, and that's what Delmarva did here. But neither staff nor the DPA agreed that the extension allowed Delmarva to file a reply brief on exceptions. That subject was never discussed, and I promise you, staff and the DPA would never have agreed to it. And here is the main difference between what the DPA did and what Delmarva did. The DPA sought and received permission to extend the exception deadline by 5 days. Delmarva neither sought nor received permission to submit its reply brief on exceptions. Now, Delmarva makes a due process argument in its motion, and I am trying to avoid pejoratives. There is no violation of due process here. The Delaware Supreme Court has held that a judicial model or an evidentiary hearing is not required in every case, but that is exactly what Delmarva got here. It submitted pre-filed testimony. It submitted live testimony. It got an evidentiary hearing at which it had the opportunity to, and did, cross-examine the other party's witnesses. It briefed its positions to the hearing examiner, and it got the last word in its reply brief. Neither staff nor the DPA raised any new arguments before this commission. We raised the same arguments to the hearing examiner. In its reply brief, Delmarva addressed every argument that staff and the DPA made, And the hearing examiner obviously accepted Delmarva's arguments. And Delmarva can argue its positions before this commission's at oral argument. It has received more process than it is due. It simply wants the last word. I'm not going to spend much time on Delmarva's argument that our brief on exceptions was 37 pages long and addressed an important legal issue, because over the years, the commission has reviewed much longer briefs and addressed other important legal issues without the benefit of reply brief on exceptions. In fact, in docket number 13-115, the public advocate's brief on exceptions was 83 pages long, and staff's was, I think, 49 pages long. Finally, with respect to Delmarva's allegations or arguments with respect to Dr. Barua's bias, we think that's meritless. We cited case law from the Delaware Supreme Court that Delmarva must overcome a presumption of honesty and integrity. Delmarva has shown nothing to overcome that presumption. Delmarva certainly didn't think Dr. Barua was biased when he initially gave it what it wanted before he had heard the DPA's position. It was only after Dr. Barua had had the benefit of both parties' positions and changed his decision that Delmarva decided that he's biased. We note that the issue of an executive director's potential conflict with respect to the hats he wears exists in every contested docket in which staff is a litigant. But never before has any party asserted that an executive director could not make a decision on scheduling because of this conflict. I've known Dr. Barua for many years, and I know him to be a man of honesty and integrity. I don't always agree with what he decides, but I would never think that he would act in a manner inconsistent with those qualities. And I said finally before, but actually this is the final argument. I would like to express our displeasure at the pejorative words in Delmarva's motion. They refer to misrepresentations by staff and the DPA's counsel. They refer to staff and the DPA being disingenuous. Those are words that suggest that staffs and the DPA's counsel lack honesty and integrity, and those, to me, are fighting words. I have attended at least 2 continuing legal education seminars called Talk to the Judges, in which the judges of the Supreme, Chancery, and Superior Courts have all stated that disingenuous is a word that they do not want to see in briefs or hear in argument. Because what one is really saying when someone is called disingenuous is that that person is deceitful, mendacious. That is not the first time that Delmarva's counsel has used these words or similar words to describe staff and DPA counsel. And I simply want to put them on notice that I will no longer stand for this. Disagreements are as to what the facts and the law are simply that. They are disagreements. And lawyers should agree to, or should be able to disagree without being disagreeable. Disagreements are not misrepresentations, and they do not render a person or party disingenuous. I thank you for your consideration and attention.
Thank you, Ms. Iori. Mr. Geddes, do you want to make any comments on that one issue that she referred to?
No, Ms. Iori has represented staff's position on this. Thank you.
Mr. Skaggs, you want a couple minutes rebuttal?
Yeah, I just need a couple. I didn't really remember that higher rhetoric in the motion. It's something that has happened here. And it's been heartfelt on both sides. I've been called some pretty bad names myself, and I would be all for turning down the rhetoric. I didn't remember in particular anything, offensive compared to what I've seen in filings here before by both sides, and I'll leave it at that. The rules and the statute, and I did mention both. Like I said, our interpretation of that is, of both of those, is what is required. And what DPA, Ms. Iori has told you is that's all that's permitted. Permitted and required are 2 things. If you want to challenge a hearing examiner's decision, his recommendations to this commission, you have to file exceptions within the 20 days or a longer period if extended by agreement or however. But we don't read that, and we see nothing in that language that prohibits any additional filings in a particular case if it's warranted. It doesn't say that, and we would think it would be backwards, sort of read it that way. If you want to file an appeal from a court decision, you have to file a notice of appeal. The case then continues on appeal to full briefing. That often doesn't happen here for a variety of reasons, including the parties don't believe that the issues coming up are precedential enough to warrant full briefing, and any number of reasons. A lot of time the exceptions are on the same point because both parties thought the hearing examiner erred, like in rate of return. So there's often not a need for further filings. This was a case, well, Delmarva thought so. This was a case, Delmarva, yes, could have filed things earlier, but this is also a case that is not that different than what happens here before this commission, as happens to utilities, such as the one example I gave about getting 1 day's notice, being forced to come in, stay up all night, argue something, get told no, and the commission ends up entering an order that violates a statute because staff decided to do something on 1 day's notice. So that what is happening. We'd be all for some more concrete rules to say, yeah, Delmarva, we're tired of it, and we're tired of the rest of you. If you want something to come before us, have it filed 5 business days before our meeting, whatever it is. Then we will know. Until then, we think we put something in as quickly as we could. It wasn't as fast as it probably should have been. But on this case, we think it should, it should be heard and doesn't violate any rule for you to exercise your discretion to do so, and would be fair to do so in the context of the issue here. So anyway, that's all I got to say.
Okay, thank you, sir.
Brief rejoinder, Chairman Winslow?
Yes,
And I
ma'am.
do mean brief.
Yes, ma'am.
Mr. Skaggs called this sort of an appeal. It's not an appeal. It is exceptions. The APA contains a whole nother area for appeals. These are exceptions. If you buy that argument, you are adding language to the statute that is not there, and that is reversible error. Thank you.
Thank you. Commissioners, do you have any questions of the parties?
Yeah, Mr. Chair, I do have a couple of questions. First, I think for Ms. Iori, are you alleging in this case that the 20-day period allowed in the rules and the statute have been violated?
No.
Okay.
Oh, I'm sorry, wait a minute. By them on this reply brief? Yes.
Okay, so the answer is you are alleging that the 20 days has been violated.
Yes, but that was not, that really wasn't the thrust of our argument. The thrust of our argument is that the APA does not provide for reply exceptions,
Okay.
and that the commission is subject to the APA.
And for Delmarva, Mr. Skaggs, do you agree with Ms. Iori's perspective on this point and this question?
First, we don't think that the 20-day limit was violated by DPA. They asked and got a continuance, so that's fine. But the point of us bringing that up in the filing was this is a flexible process. Even though it says 20 days, parties agree or the commission can hear other things. Our reply does not violate the 20-day filing because our reply responds to their exceptions brief. Exceptions is when we are contesting and we filed our own exceptions about, on the hearing examiner's report, we filed exceptions, and that was because he denied a return on the expenses. And so that's what you can know. When you see the hearing examiner's report, for the next 20 days you look and you say, do I agree with it? Do I want to contest any portions of it? Okay, you put those in. Then what we're doing in our reply is defending the hearing examiner's decision with arguments that we believe you should hear that aren't in his report because he doesn't fully report to you. You don't see the briefs we file with him. You don't see the detailed arguments we made before him. What you do see are these detailed arguments on one side, which is DPA. So we don't think we violate it. It's not an exception. It's a reply to their exception defending the hearing examiner's report. We see it as something very different.
And I see that in this case, at least as I've read through some of the documentation, that the exceptions should be focused on the hearing examiner's findings as opposed to the exceptions to another party in the case. Am I confused here or no?
No, that is our argument.
Yeah. So I guess what concerns me a little bit in so far as this motion is concerned is how long might one of these cases coming from a hearing examiner extend? And how do we then cut it off if we open up the floodgates, if you will, and allow outside of the rules and the statute that we're not able to standardize any duration within which we would expect this feedback to come for an informed decision from the commission. So I think that the public advocate makes a fairly compelling argument to me that this motion should be turned down. I'll just make that statement for the record.
Yeah, and so,
Your Honor, there's no question pending.
I'm sorry, he was looking at me. I didn't know, if you don't want a response, I'll shut up.
I have no further questions. I think
Got
I've
it.
expressed my opinion, so
Okay.
I'll yield to the chair. Thank you.
Got it.
Anyone else have any questions? Commissioner Correa?
That if by any chance, if we are adding something to the act which is irreversible, then why would you want us to make an exception to the exceptions of 20 days answer to the exception and not to the original brief? That sounds like, or am I correct in thinking that?
Yeah, I would say that's, the only thing that says that you'd be adding to the act is Ms. Iordi. She hasn't cited you any precedent. What the statute and the rules say, if you read it, is this is what you do to take exceptions. It doesn't prohibit any further filings. There's a lot of filings in a lot of cases that are undefined, that are needed by the commission, that are not specified in the rules, that you will make this filing. After minimum filing requirements, there is a case schedule put together with multiple filings of direct, rebuttal, all different types of testimony in a rate case that are not laid out piece by piece in the rules. So our point is, no, you wouldn't, of course you wouldn't be adding to the statute. That is what is required if you want to take exceptions and challenge the decision. What we're saying is more, of course, can be permitted. What DPA is saying, that's all that's permitted. No, that's what's required if you want to take the decision, and that's all the statute says. So, in our view, and we think this interpretation is correct, is it wouldn't prohibit you from receiving these filings. It just doesn't prohibit any further filings. Anyway, that's our view.
Commissioner Correa, may I address that?
Please do.
Thank you. It's not just me saying it, it is actually our courts that say it. In my papers, I did cite authority. I'll just read it to you real quickly. Where the intent of the legislature is clearly reflected by unambiguous language in the statute, the language itself controls. It is well established that courts have no authority to vary the terms of a statute of clear meaning or ignore mandatory provisions. That cite is from a case Zambrana versus State, 115A second 773, Delaware Supreme Court, 2015. You'll find that on page 4, footnote 6 of our response. Furthermore, nor may a court, quote, engraft upon a statute language which has clearly been excluded therefrom by the legislature, end quote. That is from a Delaware Supreme Court case called Hum versus Aetna Casualty and Surety Company, 656A second 712, Delaware Supreme Court, 1995. When a legislature inserts a provision into a statute, the court assumes the insertion to be purposeful. Likewise, when a legislature does not include language in a statute, that decision is also deemed to be purposeful. And the citation for that is also the Hum case. So to state that we cited no authority for our position is inaccurate.
Ms. Iori, a question for you. Under 10126, proposed orders, it reads that the parties who shall have 20 days to submit in writing to the agency exceptions, comments, and arguments respecting the proposed order. Would that language allow or permit a party to file arguments such as would be in a reply brief that Delmarva intends to file?
Yes. Yes, and in fact, Delmarva has submitted, quote, exceptions that weren't exceptions. They submitted comments in support of a hearing examiner's decision. I don't have it right now, but I could find it pretty quickly. It was fairly recent. I remember being surprised, and I went back and looked at the APA, and it's like, oh, okay, they can file comments and arguments. So I didn't object. for that reason.
Commissioners, any further questions? Mr. Skaggs, I think there's some merit to your argument that a reply brief would be of some assistance to us upon occasion. However, I do think that the weight of the law is on the side of staff and the DPA. So I will be voting in favor of the motion if Commissioner Gray makes one in favor of the state and the DPA in this matter. Any other comments?
Just a point of clarification, Mr. Chair. I think that we're deciding on a motion presented by Delmarva. Is that what we're deciding on? Or is it a motion by staff and the DPA?
It's a
No,
motion
it's
by
Delmarva.
Motion by Delmarva.
I would move, therefore, Mr. Chair, that the motion by Delmarva is declined.
I'll
Second that
second
motion.
that.
Is there any discussion on the motion to deny the motion for continuance? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any one in opposition? The motion carries. Thank you, everyone.
Thank you, Commissioners.
The next item on the calendar is the argument on the merits. There seems to be no rush for someone to go first here. Mr. Geddes?
I believe, with your permission, Mr. Chairman, that our exceptions are the ones that are probably the most extensive, and I believe are the ones that the commission probably is most interested in. But I'll defer to Mr. Skaggs if he disagrees with that.
Nope, I was waiting on either Mr. Geddes or Ms. Iori, not both, to speak, since we're not doing tag teaming. So,
I'm not speaking.
okay, fair enough.
I believe that at least with respect to this, notwithstanding the fact we filed a joint exception, that we are different parties. So I would hope that the commission would allow Ms. Iori limited comments if she feels there's something I have not covered to the extent that she feels is necessary. We are not the same party, unlike Delmarva, who has two counsel.
Please proceed.
Thank you, Mr. Chairman, members of the commission. The exceptions that staff and the DPA filed, I think are important. Obviously, given the last 30 minutes or 45 minutes, you realize that Delmarva believes that staff's position and DPA's position taken in response to the hearing examiner's position and recommendations is important to it as well. And the reason is that from a 50,000-foot level, this case and the case that we rely on primarily is an appropriate bookend, if you will, to the Delmarva case decided by the Supreme Court in 1986. Now, I will take a wild guess that there is no one else in this room that was actually involved in that case. And there was certainly no one else other than myself that argued the case, both before the Superior Court and the Supreme Court. It's an important case, but it's not on point here. Delmarva bases its position that the costs associated with a replacement battery the costs associated with replacing the IMU batteries, and I'm going to assume that the facts are pretty well known by the commissioners. I will not waste your time articulating them unless you ask me to. But the central tenet is that all utility decisions, let me say that again, all utility decisions should be reviewed under the business judgment rule, waste, abuse of discretion, bad faith. And the second tenet is that the IMU replacement battery costs are not extraordinary expenses, as distinguished from ordinary expenses. Staff and the DPA believe that Delmarva is wrong on both points, and that neither the case law in this state nor commission precedent supports those two contentions. In order to make their argument that these replacement costs are ordinary business expenses, Delmarva relies primarily on the 1986 coal case and an artesian decision that this commission made involving an office building. Now, with regard to the coal case, it did not address the appropriate standard of review for expenses that are not incurred in the ordinary course of business. Justice Horsey determined, along with the court, that the coal being purchased for Indian River 4 in the late 70s, early 80s was an ordinary expense. It was necessary in order to operate the facility. Obviously, without coal, the facility could not operate. It was a new performance, the new performance standards had incentivized Delmarva to find low sulfur coal that would avoid the cost of scrubbers. And so in 1977, they went to West Virginia and negotiated 2 coal contracts with companies there to receive low sulfur coal. The only similarity, I would say, is that then Mr. Vice President Roger Campbell believed that the market itself was a market cap on the cost that the company would ultimately have to pay for the coal. That proved to be, unfortunately, uneconomic. Here, the issue is the failure to include replacement labor costs for a defective product that everyone agrees was defective as part of the renegotiation to get the batteries removed, new ones installed, and the equipment functioning properly. The coal case does not involve an extraordinary expense. It involves an ordinary expense. And there are only 2 buckets. You have option A and option B, and there's no C, D, E, or F, at least as regulation exists and case law exists in this state. Now, they also rely on the Artesian case, a decision made by this commission in 2006 regarding an office building. And they believe that that is precedent for their opinion that the replacement costs should be judged by the business judgment rule. However, that issue was not brought before this commission. The staff and the DPA there believed that since it is a repurchase of a facility that the company had previously owned, that it was an affiliated transaction, and that the entire fairness standard, which is a standard in Delaware law, should apply to it, since there were competing interests, or say similar interests, on both sides of the transaction. Staff and DPA did not argue, per se, that it was an extraordinary expense. They were more concerned that it was an affiliated transaction, and that a different standard other than business judgment rules should apply. The commission, deciding that its decision was based on the facts of the case, held that it should not apply a higher standard because of prior decisions it had made with regard to the property in prior cases. That clearly is not the case here. We are not arguing entire fairness. we are arguing that the business judgment rule does not apply to these expenses. So the case that staff and the DPA have relied on is the Chesapeake decision, a decision written by Justice Quillen, formerly known as Vice Chancellor Quillen, formerly, actually was Superior Court judge when he wrote this one, and actually, one commissioner might be interested that he was a banker at one point. In the late 70s, he worked for Wilmington Trust. I only know that from personal knowledge. But he's a well-respected jurist. I don't think my learned opponents across the table would disagree. I don't think there's a lawyer in this room that is not familiar with Justice Quillen's work and that he was a very talented jurist.
First case I ever had was before him. He was a great fella and a great judge.
And my father hired him as a banker. But way to digress. With regard to that, Justice Quillen found, or I should say Judge Quillen, found that expenses that were labeled as extraordinary and had that moniker, as well as where the company had requested special treatment for such expenses, made them unrecoverable from ratepayers as an ordinary expense. They could not be both. They either were extraordinary or ordinary, but you can't have them be both. And what Chesapeake had attempted to do was to suggest that remediation costs associated with CERCLA liability for a plant that they'd only operated for 2 years should be treated as an extraordinary expense. And on its face, you could say, yeah, that is extraordinary. But at the time they appealed the case, because the expenses were recurring, related to this plant, related to their liability, or what they agreed was their liability, they were recurring, and so they tried to argue they were actually operating expenses. And the court was quite clear. That's, and in fact says, that is impossible. You cannot have an expense be an operating expense and an extraordinary expense. If it's an ordinary expense, it will be recurring, and it will be picked up in the test year and recovered. If it's an extraordinary expense, as Chesapeake declared it to be, it is deferred. And the company has the opportunity to get dollar for dollar recovery plus a return on that deferred asset when it's collected. So the rate-making treatment will drive whether it's an extraordinary expense or an operating expense, which would be picked up in a test year. Now, in this case, the labor costs that we're talking about occurred over a 3-year period. So the normal rate-making process, if it was an ordinary expense, maybe a third, maybe more would be picked up in the test year that the company would be basing its case on. But by deferring it, the 3 years of those costs are sitting over here. They were not picked up in a rate case. They're in fact waiting to be recovered. That's what makes it a different type of expense, and what Justice Quillen determined is that that rate-making treatment makes it an extraordinary expense. And he held further that the business judgment rule does not apply to extraordinary expenses. He did not say what standard did, but he clearly said it does not. Delaware law, and I'm quoting on page 10,068. I say 1,068, apologize. Delaware law has not previously guaranteed a utility the right to recover all of its extraordinary expenditures. The reason for this is that extraordinary expenditures do not fit neatly within the Commission's rate-making calculus. They are not operating expenses because they do not arise in the day-to-day operation of the business. goes on further and states, the court cannot call the remediation costs operating expenses and at the same time give them rate-based treatment, because operating expenses generally are, one, recovered completely when incurred rather than amortized, and are not something like plant assets upon which the utility earns a rate of return. So, what does that case stand for? It stands for the principle that extraordinary expenses are not judged by the business judgment rule, or do not, that rule should not apply, and that expenses given rate-based treatment are not ordinary. Finally, contrary to the company's view of the regulatory landscape, not every expense must be seen or approved or reviewed through the business judgment prism. Now, your own precedent, as well as the case law, supports the fact that not all expenses that the company incurs are recoverable, even if they're not the product of abuse of discretion, bad faith, or waste. For example, in the last fully litigated case, 13115, that Ms. Iori referred to, which had 100 pages of exceptions, all filed on the same day, millions of dollars at stake, the commission, the chair, and the vice chair unanimously, along with 3 of your colleagues at that time, found that non-executive incentive compensation, known as AIP, was an extraordinary expense, not necessary for the provision of reliable utility service, and thus excluded those costs from recovery. The Commission also found, in that case, supplemental employment retirement benefits, I always say affectionately, but known as SERP, were extraordinary expenses, unnecessary for the provision of safe, reliable electric service. So the central question here is not how Delmarva framed it before the hearing examiner, which the hearing examiner accepted, because the law is well settled. If it's an extraordinary expense, it's not necessarily recovered from ratepayers. But the additional labor costs that are in a regulatory asset must be reviewed under a different standard. And remember that if it is in a deferred account, the company can seek not only recovery of the expense, but a return on that expense. That's what makes it different. Now, Delmarva attempts to argue that the batteries would have to be replaced eventually. And therefore, somehow, it is a normal operating expense. I know Mr. Ori tried Hamilton. I'll just try, I've seen that movie before. And actually, probably another situation where not too many people around, early 1990s, Salem, nuclear power plant. We called it the Cook generator case, but in essence, a generator failed and a forced outage was taken. PS of New Jersey attempted to argue to the BPU of New Jersey, the regulatory body, that this was actually a benefit for the ratepayers because the forced outage then allowed the company to take its required refueling outage earlier, and ratepayers would be benefited by that. Of course, the conflation of when the refueling outage was going to be taken with the forced outage related to the generator, that several year period was lost in the analysis. A similar argument could be made against Delmarva's position here. Yes, these batteries will probably have to be replaced, but not immediately. That they do have a useful life. There's an anticipated 20-year useful life, and whoever ultimately picks up those recurring costs or those costs, it will be certainly a different set of customers I can guarantee you a different rate council and perhaps different commissioners when that issue comes before you or your successors. I don't think it has much of an argument, or much persuasion. In conclusion, all you really have to find here is that the costs associated with battery replacements, whether those costs are extraordinary. The evidence in this case showed that approximately 5% of the customers never received the battery in the first place and were paying labor costs associated with a product they had not received. This asks all ratepayers to pay again labor costs associated with a product everyone agrees is defective. The evidence is clear that Delmarva negotiated for a solution to the fact that these batteries were not working. They controlled the negotiation, they sat at the table, and they came up with a solution that was, yes, the batteries can be replaced at no cost, but all the labor costs, except for $157,000, are not going to be part of that settlement. So the question is, why should the ratepayers have to pay twice, in some cases, for something they never received in the first place? So, as the Chesapeake decision holds, special rate making treatment, regulatory asset, which this company asked for, and I believe it was docket 0728, makes the expense by its very treatment an extraordinary expense, not an ordinary expense. And if you find that to be factually correct, then the standard of review is not, as the company articulates, a business judgment rule. And you have in prior cases decided whether or not a particular extraordinary expense should or should not be recovered from ratepayers. In this case, we suggest to you that these costs should not be recovered from ratepayers. As they say, they've already given. Thank you.
Just one addition, we did make other arguments in our exceptions. We won't bore you with them here, we assume that you've read them, but we are not waiving those arguments by not discussing them today.
Yes, sir.
Thank you, Chair Winslow. So real quickly, and I'm sure the commissioners are up on the facts, but just to highlight a couple because I think they're important to your determination. Of course, an IMU is an interface management unit. It provides a radio signal of customer natural gas usage to eliminate the need for manual meter reading. And so when we start talking about could this business be operated without these, is this necessary to the conduct of the business, the answer is obviously yes. No battery, no meter reading, no meter, no gas service. And that will be important when we start looking at whether these are ordinary expenses. Now, Delmarva entered into a contract with Silver Spring Networks to provide the IMUs in about 2010. This contract was negotiated with SSN by PEPCO on an enterprise-wide basis, which allowed Delmarva to benefit from PEPCO's buying power and negotiate a lower cost than it could on its own. Contract included a liquidated damages clause in the amount of $5 million. Contract included a warranty period of 5 years on the batteries. The expected battery life was 15 to 20 years. Now, nothing in the record indicates that in those negotiations, Delmarva's negotiators ever acted in bad faith, ever evidenced any attitude of we don't care, acted irrationally or otherwise in a straightforward, prudent business manner. There's actually not even evidence that whoever could have negotiated this could have ever gotten even a better deal. So that's the record on the contract. The deployment of the electric AMI system and the gas IMU system ran into multiple challenges, no doubt. Delmarva started observing battery failures in 2010, started tracking failures in 2014. It didn't know why they were failing. It could have had something to do with the installation procedures. It wasn't necessarily a problem with the battery itself. Delmarva and Silver Spring Network decided in 2015 that all the batteries should be replaced. Delmarva initiated the battery replacement in 2016, and I believe, of course, it's done now. That's why we're here. Other problems with the deployment depleted the $5 million liquidated damages provided in the contract. Now, those damages, those $5 million, $4 million of them went to Delmarva gas customers for the problems that were associated with the IMUs. Now, Delmarva then negotiated a settlement with Silver Spring Network, and using its leverage as Silver Spring's second largest customer, its largest customer was Pacific Gas out on the West Coast, Silver Spring agreed to provide 143,000 new batteries, and that's even though the warranty period had expired. No legal obligation, but Delmarva negotiated for that and got it, despite the lack of a legal obligation. Those are valued at about $1.9 million. Silver Spring also agreed to pay an additional $150,000 toward the labor costs for replacement. Once again, no legal obligation, but we were able to get it out of them. So overall, Delmarva Gas received $4.1 million in cash plus batteries worth about $2 million in trying to settle up on this contract where there were problems. Now, Delmarva has incurred, and as you saw in the hearing examiner's report, the incremental labor cost of $3.4 million, which has been approved and recommended to you by the hearing examiner's report based on his, we believe, well-reasoned look at the evidence and the case law and the standard. Now, one other important point is the installation here of the interface management units on these meters was not Delmarva off on a frolic and detour. Some executive thought they had to gain a reputation as some cutting-edge technology utility. It actually grew out of specific legislation, Title 26, Section 1008-1, requiring this commission to evaluate the desirability, feasibility, and cost-effectiveness of advanced metering technology. That was then, this was advanced technology. Everybody knew it, including the commission, of course, when it signed off on the project. In September 2008, the commission entered an order, 7420, that established the regulatory asset for recovery of appropriate operating costs associated with the deployment of advanced metering infrastructure. Of course, nothing in that order indicated that these expenses would necessarily be extraordinary or ordinary. It was silent on that. Then in 2017, in Delmarva's last rate case, the commission approved an order entering the settlement agreement where all parties, of course including staff and DPA, agreed that Delmarva Power's incremental labor cost arising out of the IMU battery replacement project will be deferred into the continuing AMI regulatory asset. Again, we're going to put these into this asset. In this case, the settlement of the rest of the gas case is the only issue that remains and is disputed. That was settled, and that included staff and DPA signing off and agreed to settlement of all other all their IMU-related expenses, including the metering expense, which you saw in the papers, and the DPA witness complained about that. Gee whiz, this whole thing has just gotten so expensive. It's white elephant. So please, in fairness, we just don't think the Delmarva should be able to recover these. And as the hearing examiner pointed out, that's not really consistent with what you've done here. You settled on these other costs, and so to raise this bigger complaint about overall cost is not well-founded here. So we should keep the view here narrow as to whether this is a expense that should be reviewed under the business judgment standard. And of course, we say it should, and that in Delaware, utility expenses, capital expenditures, contracts, those things that are part of business judgments made by the utility are subject, are reviewed very deferentially by courts, agencies, boards, commissions. And the reason behind this, and this is important, I'd like to stress it to the commission, is because Delaware law says folks that sit in commissions or courts are not business folks, and they may very well, actually, even if they are very good business folks, they don't know this business. So it's not exactly you're not qualified, but you're not in that business, and Delaware law says you don't then go second guess the person who's on the scene, the professional business person, on the incurring of those costs unless, and that's where the standard comes in, unless it's bad faith, right? That person, for example, if the CEO of Delmarva were to negotiate a contract for new trucks and he also owned the truck company, gee whiz, that's a real problem, right? So if it's bad faith or waste, or if it's irrational, you can't figure out any reason why somebody would do some contract like this this makes no sense. And that's the review, because these, in Delaware, we don't second guess business folks. That is the business judgment rule, and it's longstanding, and both in corporate law and before this utility. It was established, of course, without doubt, in 1986 by the Delmarva decision. So bad faith, waste, or abuse of discretion, also described as a we don't care attitude, or that the decision was irrational. Now, here, and there's one other important point about that is glossed over by staff and DPA. When someone challenges a business decision made under the business judgment rule, it is that person's burden to show it was irrational. The business person gets the business judgment presumption, which is it's done in a normal business setting, then the person challenging has to show that it's irrational. There's some other problem with it where it shouldn't receive this deference, bad faith, a conflict of interest. And of course, that means it just didn't happen here. There was no showing by staff or DPA. In fact, the showing was that both the contract was certainly rational, and that the settlement, which Ms. Lefkowitz, our witness, spoke to at the hearing, was extremely reasonable and turned out actually quite favorable to Delmarva. But that's not the standard. The standard is much, much lower. So, two attacks by staff and DPA. One is that the business judgment rule does not apply. Secondly, the one in their papers, which they didn't talk to, but I'll need to, because we're not going to have papers, is that even if the business judgment rule applies, they say the IMU labor costs are not recoverable. So, does the business judgment rule apply here? And the answer is, of course. Staff and DPA would like you to rule that the only thing that the business judgment rule applies to are only those, what they would term ordinary operating expenses, and they would define those only as those types of expenses that recur, that are done in a rate case, such as salaries, such as gasoline for the trucks, those things that are going to happen over and over and over that will go into rates and are subject to happening just occasionally or just once. Well, that's not true, and that's way too narrow, and the case law shows that. And it starts with the Delmarva case, which Mr. Geddes talked about, and that Delmarva sought to recover higher costs for coal under a fuel adjustment clause, not in regular rate making, not as an ordinary expense. The Supreme Court still said it's business judgment rule. Delmarva had agreed to a coal price formula that produced higher than expected cost to Delmarva. A second supplier then, once again, here we go, look at the parallels to this case where the problems arose. A second supplier failed to deliver coal, so Delmarva acquired coal from another supplier at a higher price. Of course, staff, DPA didn't think that the ratepayer should pay for that. And to boot, Delmarva didn't take legal recourse against that second supplier who failed to deliver. They didn't sue them. They didn't seek legal recourse. And the commission and the trial court said, the first level court said, that you can't recover that. Well, the Delaware Supreme Court reversed and said, yes, it's a business decision. It's recoverable because it's not abuse of discretion, bad faith, or waste. And the Supreme specifically rejected a prudent standard. So if you're going to go in and second-guess business decisions, and some states have this, not Delaware, to look at was this really a prudent decision when I look at the overall decision. It's not available for review by this commission or other agencies or courts in the state of Delaware. Now, we believe that just this case, the Supreme Court case, the only one cited to you, dictates the results here. It's very analogous, very close. In Delmarva, the coal contract did not go as planned. It was more expensive than people expected. And in fact, when they went to get a second supplier, they didn't even deliver. And staff disagreed, thought those were really bad business decisions. You should sue them. You shouldn't have agreed to that formula. Look at this case. Delmarva made business decisions to carry out the General Assembly's directive to move forward on smart grid technology. The contract for the IMUs and the AMI certainly didn't turn out as they had hoped for. They ran into challenges just like with the coal contracts in Delmarva. Delmarva made business decisions, settling with Silver Spring Networks to address the problems. Here again, staff and DPA merely disagree with those business decisions. They've not shown to you those business decisions were irrational, that the executives that were sitting at the table negotiating them didn't care, had a conflict of interest, or in any way acting in bad faith. So that's the end of the analysis. And this particular expense was non-recurring. This wasn't the ability to go to that second supplier, right, which they said should have been done, and seek redress. That's not a recurring expense. That would be a one-time award. And that's what the Supreme Court said we're applying the business judgment rule to. It's not just these normal expenses. It was applied there in this non-recurring setting. The batteries, as I started out saying, are much like the coal. They're needed to operate these meters, to operate the utility. So Delmarva, we believe, really does dictate the result here. It's very close. The Artesian rate case, there the commission applied the business judgment rule to expenses associated with the acquisition of Artesian's headquarters building. These obviously were not ordinary operating expenses that would normally go into as a component of rate base. Obviously not. It's a one-time acquisition of a headquarters building. This commission still applied the business judgment rule. And the commission didn't attempt to second-guess those business decisions. Now, the staff argues that Artesian decision was somehow limited to its facts, that it shouldn't be considered precedent. But the basic fact that they can't deny, that drives the important point about that case, is that the commission applied the business judgment rule to these one-time, non-reoccurring acquisition expenses because it was a business decision necessary to running the company. And it shows a much broader application of the business judgment rule than the staff and DPA would ask you to adopt here. Now, Chesapeake Utilities found an extraordinary expense. Now, how rare are they? Chesapeake Utilities is the only court decision since 1986 that found an extraordinary expense. Chesapeake sought a recovery on a return of expenses associated with a legally mandated cleanup of property under the federal Superfund law. Delmarva did not own and had not operated that property ever. Yeah, Delmarva hadn't either, but in case someone's here from the EPA looking for more money, but Chesapeake had not ever owned it or operated it. So clearly it wasn't part of a business decision over operations. It was a legally mandated cleanup on a completely separate property. So that is what we would say the very wise Superior Court Judge Quillen, who was on like every court in the state, who taught me in my bar admissions course before I took the bar exam. I guess we all have a connection with him. But the Delaware Superior Court did deny recovery on the return of the cleanup expense. And I'll get to the important point about that in just a second. And it didn't apply to the cleanup expenses. And once again, he said this isn't necessary to operating, and it wasn't. They didn't operate the site ever. Here we have batteries. You gotta have batteries. You gotta have batteries to run those meters. You gotta have the meters to have gas expenses. It's just not the same. I think also one really important point is Mr. Geddes offered this commission, what the staff sees is this bifurcated, one way or the other. Extraordinary, not recoverable, ordinary, recoverable. We don't think the case stands for that. So even if this commission decides that this was an extraordinary expense, the question would be, is it recoverable? And I'll tell you why that's a false dichotomy, because the main point is that in that case, the commission allowed what Delmarva is seeking here, the actual expenses. The commission allowed the expenses for the cleanup to be recovered, even though the Superior Court then said they were extraordinary. Okay? The Superior Court simply denied a recovery on those expenses. So it's very clear then that even if the expense is extraordinary, it doesn't mean it's not recoverable. And what we don't have is some standard to say what's recoverable in the extraordinary realm and what isn't. It's not been clearly defined, but they're clearly recoverable. And here, of course, we don't think you need to reach that. If you do reach that, it would be difficult, but there's really no reason, because these are clearly a non-recurring, though it will recur again, it's going to be more battery replacements later. So in that sense, it very much is recurring expense that is at the heart, are necessary to run the business, and therefore it comes under the business judgment rule. Now, the idea that these are extraordinary because they were placed in a regulatory asset, we would also say is not a real distinction that this commission should look at or rely on in deciding whether they're extraordinary. Holding expenses in a regulatory asset addresses the timing of when they will be considered by the PSC and recovered, not whether they relate to a business decision or are necessary to running the business, not if they're part of operating the utility. There's no bearing on that important part of whether the business judgment, the reason why the business judgment rule applies, because something gets stuck into a regulatory asset. It is a matter of timing and efficiency. And in this case, staff and DPA agree. The parties agreed to put that expense in there because it was continuing, but this particular set of battery expenses wouldn't continue forever. So let's finish what are the problems associated with this, then we'll have the commission look at it. It's a matter of timing, convenience, and efficiency. Doesn't go to the nature of the expense and whether the business judgment rule should apply, because it is a business judgment on operation of the company, which is where the business judgment rule applies. So the fact that it's put in a regulatory asset we would say, just on plain forward, straight, dead reckoning logic, can have nothing to do with whether the business judgment rule applies. So we do believe these batteries have to be, of course, replaced on a regular basis. And a couple other examples. So if you say this is an extraordinary expense, what will the commission say when Delmarva decides to install GPS on all its trucks? They have them already. I made this up. Okay. A business person makes a decision that we can increase fuel economy, we can prevent, the employees from going over to, Delmarva Park and gambling their lunch hour using our truck, or for whatever reasons the business.
Delaware Park.
What did I say?
You said Delmarva Park.
Delmarva Park.
We do not own a casino. Nah.
Though we're thinking that, anyway, you guys don't regulate that, do you?
That would be extraordinary.
Yes, that would be
And
extraordinary.
we would agree.
Anyway, so what happens when they do that? What happens when Delmarva installs new transformers? What about the labor for that? Every time you will hear it's extraordinary and non-recoverable. Every time there's anything done as a business decision to improve operations, to address problems, the expense, capital will be taken care of, rate, the expense associated with that, if it's non-recurring, you will have staff tell you can't be recovered. That just cannot be. That cannot be. That would just not work with assessing to the customers the actual cost of doing this business. So if you consider where this would lead and where the logic takes you, it cannot work. So staff and DPL also offer these other arguments, and I'll go through them quickly. about even if it does, even if the business judgment rule applies, then you should still deny this expense. Once again, I start where I started out, which is it's their burden, if this is a business judgment rule, to show that it was bad faith, waste, irrational. We don't care. Clearly not present here, as you saw from the hearing examiner report, who found the facts, who haven't really been disputed here. There's no dispute of the facts and how Delmarva acted. There is some disagreement with the things Delmarva did, but nothing to show that they were done in bad faith or irrationally. So staff and DPA assert that the hearing examiner's report can't be relied upon because it's based on hearsay. There's several problems with that. First, we believe the challenge here is primarily, I mean, if the challenge is to the contract and staff and DPA intended to really challenge the terms of the contract, they failed at the outset. They didn't put the contract in the record. So that it's hard for them to assert it was an irrational contract when they haven't even shown the terms, all the terms to the hearing examiner or this commission. Ms. Lefkowitz not only provided the firsthand testimony concerning the settlement, but she did become familiar with and the corporate representative to testify on facts, those secondhand, of what occurred in the original contract negotiations. So there was a fair record made of that. Of course, the hearsay objections are waived if not made at the time of the hearing. That's not just a purely technical point, because if someone objects to your evidence as hearsay and the hearing examiner sustains that objection, you may need to get that, and you may have a way to get that testimony in another way. So if someone doesn't object, it goes in, then they've waived, because even if they objected, you lost the opportunity to perhaps get that evidence in another way because the hearing examiner said you can't do it that way. So that really does matter that those objections come in. And here, staff and DPA even asked questions that elicited hearsay on this exact topic. If you look at the transcript at page 107, you'll see staff asking this question. Okay, DP&L or PHI made the decision to purchase the IMUs from Silver Spring, correct? What had to do with the initial contract and the decision? And staff is asking it. So, commission's also not bound by technical rules of evidence. That's 26 Delaware Code 503A. So enough about the hearsay, I think. Examiner, they also assert the examiner did base his decision on evidence outside the record, and they complain about the use of or the hearing examiner's citation to testimony of a Christopher Crane from another docket. Yeah, we think we can't really find in that testimony the facts that the hearing examiner cited it for. That testimony really doesn't include the facts that the hearing examiner cited it to establish. So we think it was just a mistake. But certainly the use of testimony from another docket shouldn't be disqualifying. In fact, staff and DPA obtained admission of testimony of Gary Cohen from another docket over our objection. The facts that Mr. Crane's testimony was cited to establish had to do with the results of the settlement. The $4 of the $5 million of the liquidated damages going to Delmarva gas customers, the $157,000 paid for labor costs for replacement, the $143,000 batteries, and the value of those batteries are what that's cited for. If you look at the transcript, Ms. Lefkowitz on pages 133 and 152 and 153 established those same facts. So they came from someplace that weren't outside of the record. There's also a section that we had a hard time understanding to respond to that said that the hearing examiner could not use facts after execution of the contract to establish that it was a reasonable business decision. There were facts about the contract. There were facts about afterwards that also included the settlement. So there are any number of facts. The hearing examiner looked at all those, made his decision. Once again, if you fall back to it being the burden of staff and DPA to show that it was bad faith or irrational or a waste of assets, then really it was up to them to worry about proving that, not exactly how we got where the hearing examiner cited which facts. There was a third-party beneficiary theory where staff and DPA alleged that, or argue that the ratepayers were third-party beneficiaries of this contract, and therefore they have an interest in it and shouldn't be charged twice. That theory doesn't work. In order to be a third-party beneficiary, you have to essentially be identified in the contract. The ratepayers, customers weren't identified here. It's also not something the commission should look at, because if you are a third-party beneficiary, it gives you the right to sue the party who provided the defective performance. So that essentially would say ratepayers could sue Silver Spring, not that ratepayers have any greater interest in what's going on here today. It's just, there's just no application for that theory in this regulatory proceeding. It's a theory of contract liability among private parties. So if you look at the rest of the complaints, such as this whole thing was a white elephant, such as the amount of liquidated damages wasn't enough, that's one of the complaints. It should have been more. And the reason, this once again highlights why we have the business judgment rule. Because when that negotiator sat and he agreed to, from Delmarva, said, we will take $5 million in liquidated damages cap. That in an overall business deal is linked to other terms and considerations. So if he took a $5 million cap, in his judgment, it was worth it to probably get a lower price for the units. If you pay for a higher warranty, 10 years or a $10 million cap, you're probably going to be required to pay more for those units. It's always a trade-off, such as you can buy the extended warranty on your car, right? It's going to cost you more, but you get more covered later. So it's that reason that Delaware says that you've got to find something really wrong in the process, and the person challenging it has to prove it. And so these other things brought up by staff and DPA are complaints. I will only touch on our exceptions very quickly. Delmarva did file an exception. The hearing examiner denied any return on the expenses, although he allowed the expenses, and found them subject to the business judgment rule. Our simple point is, if it is subject to the business judgment rule or even otherwise recoverable, and as I told you, just because it's extraordinary, our case law does not say that means they're not recoverable. But if they're recoverable under law, then we don't understand, and I don't think the hearing examiner gave us an explanation. If they're recoverable and they've been sitting there and deferred, why there shouldn't be a return on them if they're legitimately recoverable. So that simple point. And then he gave recommended payment terms for recovery. He recommends payment over 3 years, divided between the first year for a certain, or first 2 years for a certain amount, and the other year. We find that actually reasonable, but we have to point out that they would not be in compliance, probably be in compliance with the settlement of the rest of the case, because it provided, the settlement agreement provided, that any recovery on this would be recovered through the rate design agreed to by the parties. So that may be somewhat technical point, but if there's recovery, it should probably come through that rate design, because that's what the party agreed to in the settlement agreement. So I know I went on for a while. I saw you all listening very intently. That must be hard to do, particularly to me, for that long. So I very much appreciate your attention, and I'm done.
Thank you, Mr. Skaggs. Mr. Geddes?
Brief comments. I would request that Ms. Iori, if you could see her body language, would probably have a few comments that if I don't touch on all of the things that she's asked me to touch on, since Mr. Skaggs has been speaking to you, but I'll be brief. I find it curious that Mr. Skaggs mentioned twice that we have the burden of proof here. If we have the burden of proof, why do we spend the first 45 minutes on reply exceptions? Normally, the way it works, if you have the burden of proof, you have the last word. So if we have the burden of proof, why were they insisting on having the last word? I'm not sure I understand that, but I will move on. I think Mr. Skaggs has done an admirable job, as he always does, of trying to emphasize what supports his position and, shall we say, de-emphasize what does not. The Chesapeake decision cannot be dissected the way that he asks you to consider it. We did not create a false dichotomy. We basically said consistent with the decision that you cannot apply the business judgment standard to extraordinary expenses. We didn't say what standard should apply. We also did not say that all extraordinary expenses are not recoverable. Clearly, expenses associated with hurricanes, expenses associated last night with a tornado, they're extraordinary expenses, and I don't think you would hear staff or anyone oppose the company's recovery of those in a proper rate setting. The issue about the coal case, which is their case, in the sense of they've got their arms wrapped around it pretty tight, sort of, I mean, I was not quite here, but I certainly was aware of the reasons why 303 was passed, and that was because of the oil embargoes. Fuel expense for operating power plants has always been an ongoing operating expense. It was broken out in a separate statute section because of the rapidity with which prices were changing. It was to accommodate and try to help the utility in a high-interest environment to be able to try to keep up with costs that were ratcheting up at dramatic levels. The fact that it was segmented into a separate, or reviewed under a separate statute section has nothing to do with the underlying nature of the expense. Fuel is an ordinary expense needed to generate electricity. With regard to extraordinary and ordinary, I mean, these AMI meters replaced existing meters that were working fine. So they clearly were not necessary for the normal operation of the utility. They were touted, as many times things are touted, as saving money. Now, the record is, shall we say, not one-sided on whether they saved money or not. Clearly, there was, on behalf of the DPA, testimony that they were really not saving ratepayers money. But the point was, they replaced existing meters, and there was no testimony that those meters weren't working properly and providing the necessary signals for our customers to receive their gas services. I find it interesting that sort of at the end, Mr. Skaggs went off on the, shall we say, the record, and hypothecated, with no facts and no evidence, that perhaps the prices for the batteries were somehow different because of the warranty issue that we had raised, which was if you take your car in to get replaced, you know, an airbag, you know, because half of them don't work properly, you don't pay the cost for that replacement. We tried to analogize that, you know, the ratepayers got a defective product. They shouldn't have to pay to replace it once they paid for it the first time. But of course, what he fails to mention is that the company's main witness wasn't involved in any of these negotiations. I mean, she came in after it was all done. No one really knows what the quid pro quo, what was given, what was received. The point was that the ratepayers are left holding the proverbial additional expenses in a round thing that some people call a bag, because they weren't at the negotiating table either. And so if you are trying to apply equity, why do the ratepayers have to keep paying again and again? If this is an equitable analysis, I would think that there would be some equity on the part of the ratepayers that should be called into account. And Justice Quillen is very deferential to the commission in his decision, the Chesapeake decision, because he talks about the commission's discretion and the fact that the commission can create equity. In that particular case, because of the facts, it was decided that a split would be appropriate. But you just heard the conclusions of counsel that they are accepting to the hearing examiner's opinion in this case because they want to return on those expenses, even though previously they've agreed they would settle without getting that return. The difference between extraordinary and ordinary, I did point out, but I would like to just touch on it again, when it is a deferred accounting, the company has 100% opportunity to collect 100% of the expenses if they are not found to not be collectible for another reason. That's not the same with ordinary business expenses. And you can try to put, I don't want to go down that metaphor. You can try to call this whatever you want, but it's not an operating expense. If it was an operating expense, it wouldn't be treated this way in the rate-making calculus, as Justice Quillen so carefully noted. Let me just see if there's one other issue that I need to address. No, I think that's all, but I'm sure Ms. Iori will fill in the issues I missed. Thank you for your time.
Actually, I only have one, and and it refers to Delmarva's statement that the General Assembly has, directed them to consider advanced metering infrastructure. And that is true, but only for electric. That section is 26 Delaware Code, Section 1008B1, small a, which is in the Electric Utility Restructuring Act, and it states, the commission is hereby granted the authority to require DP&L, subject to its jurisdiction, to develop and implement demand-side management programs designed to reduce overall electricity consumption by its customers and/or to reduce usage by customers during peak periods, such as time of use rates, advanced metering infrastructure, etc. And then in little subsection B, by June 5th, 2006, the commission shall open a docket to evaluate the desirability, feasibility, and cost effectiveness of requiring advanced metering technology to be utilized throughout or selectively in the service territories of DP&L. This was in the Electric Utility Restructuring Act, not the Gas Utility Restructuring Act. So there was no requirement by the General Assembly that Delmarva implement AMI for gas meters. Thank you.
Thank you, Ms. Iori. Commissioners, you have any questions? Commissioner Conaway?
No, down here.
Commissioner Gray?
Thank you, Mr. Chair. I have 4 questions, please. Can you tell me what functional deficiencies motivated the decision to replace all of the IMU batteries and when?
Well, I do know that there was a certain percentage of failures, and it got to a certain level. There was a decision along with Silver Springs to replace them all. It thought, once again, that was one of those business decisions. This is going to be the best overall and cost-efficient result. I don't want to tag team. I do have someone sitting to my left that knows more facts about those failures, but if you'd like to hear from him, he would probably tell you more facts about that.
Categorically, can you address any functional deficiencies?
Yes, we can do
Yes.
that. Yeah.
I can
Just
answer
briefly,
that
just
question.
briefly,
I think
please.
you really want the facts, so despite what objection they may raise, I can give you that answer, and I think it's what you deserve.
Hold on a
I-
second.
Ms. Iori?
I am going to object because the only facts that can be considered are those that were presented to the hearing examiner.
And they were
So to
presented.
the extent that they submit, that there's anything new, the hearing examiner's report
All right.
contains a pretty detailed description
Let me ask
of
the
the
question,
facts.
let me ask the question a different way, Ms. Iori. Is it Delmarva's position that functional deficiencies prevailed, which motivated the decision to replace all of the IMUs? That is a yes or no question.
Your question addressed IMUs. The IMUs weren't
The
replaced.
IMU
The
batteries.
batteries.
Yes. The question is.
Yeah, they were failing, yes.
Okay, thank you.
Yes. Batteries were failing.
In the interest of looking out for the ratepayers' future, how were the replacement batteries selected in a way to prevent them from failing again?
We're gonna have to play whisper down the lane, because he doesn't want me to answer, so I will answer.
Why
Well,
don't you
let me
Mr.
ask
Skaggs-
it-
why don't you- Mr. Goodman, why don't you let Mr. Skaggs just do the answers?
Let me ask again a different way. were the replacement batteries selected in such a way as to prevent them from failing in the future? Yes or no?
Yeah, yes.
Okay.
That evidence is not in the record.
I understand that, Ms. Iori, but I have a reason for the direction I'm.
I know, but I'm not doing this to be contrary. I am doing this just to protect the record if that should be necessary going forward.
Understood.
Thank you.
My next question is, were the IMU batteries used and useful?
I'm sorry, I was
Were the
distracted.
IMU batteries used and useful?
Yes,
Why did you replace them?
because they were failing sooner and at a rate that made it the best business decision to replace them at that time. They were being used. They were just failing at rates that led to the very rational conclusion that they should be replaced before their end of their expected life.
I'm going to render an opinion that if they were failing, they were not useful. That's my opinion, okay? So I'm going to just make a statement as to the ROA on a second labor cost. I'm concerned that that might motivate poor quality outcomes such as defective batteries in this case, right? GPS systems, because the prospects for recovery from ratepayers and returns on these recovered costs could amount to enhancement for utility shareholders, enrichment for utility shareholders. So this for me would be an undesirable incentive as well as an undesirable incentive. I think most ratepayers would see it that way as well. So I'm really not in favor of an ROA. But those are the substantive questions that I have. Thank you, Mr. Chair, for the opportunity.
Mr. Skaggs, do you have any comment you want to make with respect to that?
Right. Yeah, on the return, you know, we just rely on our exceptions, and I think the arguments that we make on the actual recovery of the expenses would say that the business judgment rule would say here that if you review it under that rule, then those are certainly recoverable. And so, Commissioner Gray, I certainly your opinion on the return is something that we've stated very plainly and shortly in our exceptions, and we'll rely on that as far as that the return goes.
Commissioner, I do want to point out one thing. As Ms. Iori said, there is a rule that's been pointed out to me, 2.20.1, oral argument before the commission. The commission may exercise its discretion to hear argument on exceptions. Oral arguments shall be limited to a discussion of the legal or regulatory issues and a restatement of the facts in the record. No new evidence shall be presented in oral argument except by direction of the commission upon a motion to reopen the record. So we don't want to get into things that are not on the record before us.
Thank you, Mr. Willard. Are any other questions by the commissioners? Commissioner Drexler?
My question is for Mr. Geddes. So you contend that not only ordinary operating expenses are treated as recoverable under the business judgment rule, correct?
If they are found to be appropriate, yes. There's a standard of review, yes.
Right.
If that standard of review indicates they should be recovered, ordinary business expenses should be
Okay.
recovered.
And this request for extraordinary rate-making treatment for these costs make them excluded from recoverability as it is defined by the hearing examiner.
To answer your question, we believe the hearing examiner applied the wrong standard because these are not operating expenses by definition because they sought special rate-making treatment, and the decision in Chesapeake says therefore they're extraordinary.
Okay, and you used as an example the tornado as being an extraordinary expense, tornado remediation. So what treatment of these costs would allow them to be recognized as a component of rate base or otherwise recoverable if they are indeed extraordinary? And are they excluded because they're not the same as tornado remediation?
I believe the commission has discretion on the recovery of the inclusion of extraordinary costs in the cost of service to serve ratepayers. It's our position that these are not necessary for the operation of the utility, that they're not used and useful, and that the labor costs associated with them is not therefore recoverable. That already in rates are a set of rates that allow the company to recover costs, and these have been, the costs associated with the batteries and the actual cost of the batteries. The only costs that have not been allowed so far, and that's at issue, is the incremental labor costs to replace the original defective product with a presumably product that works.
Mr. Correa.
As I understand though, the basic small direct issue is, should the charges be levied on the customer again and again and again? That is the basic issue. Whether the contract was negotiated in good faith, whether the CEO's brother-in-law owned the truck company from where the company was buying the trucks. To me, all those things are not really relevant in my decision making or understanding this thing. The basic issue is, should the customer be paid, be charged again and then again? Whether batteries were failing, whether they were purchased with good faith or not, nothing. Should the customer be paying for the same thing twice? Am I correct?
Yes.
A small example may not reflect 100%, but say there's a doctor here, and Dr. John, he buys a car, $60,000 car. IRS allows 5 years of depreciation, so depreciation will be $12,000 a year, and the expectant life of the car is 5 years. Suppose after 3 years, he finds that there's a better car, and he says, well, I'm going to dump this car, and the loss I incur on that car, I'm going to charge it to my patient. Then I'm going to buy a new car, $80,000 car, and then I'll charge the depreciation to my patient also. Would you as a patient accept that the loss on the old car, which was supposed to last for 2 more years, you say, well, let's go ahead and change it, all of them, because few of the batteries are failing on a statistical basis. But then we change all of them because it's a good business decision and the Delaware law allows it. And that's very, very convenient because we all do it at home all the time. But buying a new car maybe at the $60,000, not even 80, but charging the full depreciation again to the patient over and above the losses of the first car, that kind of a issue seems to be the issue here. Am I?
If that's a question to me, the answer is, quite frankly, no. That's not the issue, and that's not your decision point. Your decision point is whether this meets the business judgment rule because it has to do with operating a business. And let me take your analogy if I could. Because in your analogy, the car is providing a personal benefit to the physician. He gets that. He gets to charge off his patients and drive around in a brand new car. The Delmarva executives, those people who are out negotiating for the ratepayers, when they do that in good faith, right, and they make the kind of effort that is reasonable within, and that we have here, there's nothing to indicate they weren't, then the answer is that is recoverable because your business judgment can't be substituted for theirs in the standard. So yeah, I wouldn't put up with that as a patient because you're driving around in a Cadillac and I'm paying for it. Well, these executives at Delmarva, they didn't drive out of the negotiations with a Cadillac because they negotiated for something either in the settlement or the original contract. They were there only for one purpose, and that was for the Delaware ratepayers, and that's the only thing in the record. They got nothing out of this. So your analogy, I say, is off base because of that personal component. Unless you have something like that, then yeah, you have to pay again. Look at the Delmarva case, the seminal case from our Supreme Court. the ratepayers arguably had to pay again. They had to pay more for coal, or you call it again, or you call it more, or you call it overcharged. They had to pay more for coal than they might have because of the formula in the contract, and then how Delmarva dealt with the second supplier. They didn't go after him, right? So why should the ratepayers? You didn't go seek recourse. Why should they have to pay? Again, when you could have gotten it from another supplier. Well, our Supreme Court says no. They were negotiating in good faith. There could have been, and I'm making this, for example, the cost of litigating against that coal supplier could have been more than they might have expected to recover. Who knows? But they're in there making that decision, so you don't second guess those things. So the idea that that customers, it may offend some sense. This didn't work out as well as it should have. They may have to, quote unquote, pay again. They didn't really. This didn't work out as well, is not something that comes into the calculus under the law. It's a little bit hard to get, and it can feel a little bit like it's not equitable, but there's a reason for it, and it's the law. I don't know if that's helpful, but that's what we're saying, and we believe that's the law.
Mr. Skaggs and Mr. Geddes, let me just see if I can ask a very practical question. I probably should have asked at maybe the beginning of the whole proceeding, and that is, the decision you want us to make basically is whether or not we agree that the decision by the hearing examiner that the business rule applies is a correct decision or not. Isn't that the basic decision you want us to make today?
I can answer that. Yeah. Well, I'm sorry.
I asked Mr. Skaggs
I
first.
apologize.
Yes, yeah,
You asked-
correct. We think that should be affirmed. If you don't, I think there's the next questions about extraordinary expenses, but yes.
That's the central question, is that we don't think that the standard by which the hearing examiner rendered his decision is the appropriate one.
So let's do it one more time, and very, very briefly, please. Now, I think Mr. Geddes and Mr. Skaggs hit on this, but explain to the commissioners, myself and the commissioners, why the expense for the labor to install the new batteries in the interface system was not an expense, it was an ordinary expense and recoverable. Mr. Geddes.
Because the standard of review is not business judgment. 2, you can apply your own standard. 3, this was a repeat, Commissioner Correa's example, of something that the ratepayers had already paid for once. They shouldn't be expected to pay twice for the same thing, and in some cases, twice for something they never got in the first instance. So it's an expense that you should review, not under the business judgment rule, but under your own equitable consideration as between the ratepayers who are paying this and the fact that the company, by the rate treatment it sought, will get 100% recovery of those costs rather than like an ordinary expense in a test period.
You say it's not an ordinary expense, but let me just ask you this question. In the operation of a business, things do not always go perfectly. So errors or problems need to be corrected. Does that automatically make them extraordinary, or isn't it to be expected you're going to have problems and there are going to be a certain amount of ordinary expenses, lawyers, or whatever it might be to rectify the situation?
Well, I'm
For
glad
example,
I'm sorry.
labor to put in new batteries.
I'm
Why
glad-
wouldn't that be, I'm sorry, go ahead,
No, I thought you were finished. I apologize.
no problem.
I just like the fact you use lawyers and lawyers' fees, because that's one of the illustrations by Justice Quillen of a recurring expense. But no, that type of problem would be recovered as an operating expense reviewed in a test period context. So that if that expense varied up and down, the test period would look at it, and unless somebody tried to normalize it, that would be an expense that would be reviewed under the appropriate standard, which we agree, and recovered. But the next year, if that expense jumped 3 times, it would not be recoverable, because the company presumably would not be in for a rate filing unless it's filing every year. Their normal is like 3 years. However, because of the rate-making treatment, that additional cost in year 2, year 3, year 4 is being captured in the deferred asset account. That's the difference. That's why you can't have ordinary and extraordinary reviewed similarly.
Mr. Skaggs.
Yes, so I think the term ordinary is what we would see is, and this is something that, and the terminology is not precisely used always, as always happens in law and case law. It's really broader than something that would be considered ordinary in the rate-making sense that it's always recurring. So the business judgment rule clearly applies more broadly than that. The Delmarva case stands for that. The Artesian case, where there were one-time lease expenses that got business judgment rule deference, also stands for that. So it's those business decisions related to the necessary operation of the business. That's what gives business judgment rule deference. The only case finding something else was on a property that the utility never owned and operated. It was just a legal requirement, bam, imposed upon them. Here, the use of batteries in a meter is clearly something that's needed on a day-to-day basis. The fact that they had to be replaced sooner and how those were replaced, how they were replaced and they had to be replaced sooner, those business decisions to leading that are part of the ordinary operations of the business. Things are gonna fail. Things aren't always gonna work out. That's typical. And so if you look at the decision made, then we would say this business judgment rule applies much more broadly. The fact it's in a deferred account, once again, if the parties had not agreed to defer this expense, Delmarva would have sought it in that last rate case, like every other expense. Thank you.
Commissioners, any more questions? I move that the commission adjourn for the purpose of consultation with legal counsel with respect to the legal issues only. And then we will come out of special session and finish this up.
I second.
Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The commission is going to go into executive session for the purpose stated and